executive people, you kind of. Okay, good morning. I'm Dave Cortese, Chair of the Housing Land Use Department Transportation Committee, here with Vice Chair or Co-Chair, Supervisor Mike Wasserman. We're both in attendance, so we've established the necessary quorum to take action today. And I'm going to turn to my right on the dais. And first, I'm going to ask for introductions here, but I do want to publicly announce but congratulate Rob Courtney, our Parks Director, on winding up approximately 7 years here with his retirement. And we did have a chance to recognize him as a board on Tuesday. But given the fact that you are steadfast here and have done so much work in this committee, great work over the last several years that have come through the committee, regardless of who's been chairing it and which supervisors have been here. We wanted to give you a nod here and thank you one more time for all the hard work. So I've sort of introduced you already, but you're welcome to speak up. Thank you.
Thank you, Chair Cortese and Supervisor Wasserman. Thanks. It's been a pleasure to work with both of you, the entire board. You guys make doing the job here easy with the support and leadership you provide on behalf of the department, the county in general. So it's been an honor to serve here. Rob Courtney, Director of Parks and Recreation for a couple more weeks.
Thanks, Rob.
Joe Zintik, Director, Consumer and Environmental Protection Agency.
Good morning. I'm Harry Freitas. I'm the Director of Department of Roads and Airports.
I'm Kirk Gerard, Director of Planning and Development.
Sylvia Gallegos, Deputy County Executive.
Steve Mitra, Assistant County Counsel.
Okay, and Supervisor Wasserman, before we go to public comment.
Thank you. I wanted to echo what you were saying about Rob, not only here at Hewlett, but obviously with my district. I know Supervisor Cortese's district. We have park issues every week, one way or another, one reason or another, and you and the staff that you've led and that you've mentored and that you've trained have been extremely responsive, extremely helpful. I also want to thank you for making the opening of Marshall Cottle Park a reality, being involved with that, your help with negotiations with the water district on park land area, with residents as far as helping them understand when the water's low and they can't use the water, it's not our fault. And when there's issues in the various parks with lights and trails and bikes and weed abatements and everything else, Rob, your department has always been extremely responsive, extremely professional, extremely helpful, and I credit that to your leadership. Thank you very much.
Okay, thank you, Supervisor Wasserman. And we'll move now to public comment. We do have a couple of requests to speak. This item is reserved for persons desiring to address the committee on matters not on the agenda. Speakers are limited to 3 minutes. If we deem that there are 5 or fewer persons that want to speak under public comment, that appears to be the case. We have 3 requests under public comment. I just want to disclose one of those requests would have been a person speaking on item 9, but item 9 is being held. So we'll go ahead, that's Marcy Gersten, so we'll go ahead and call Marcy Gersten up to just speak under public comment. And you're certainly welcome to come back when the item comes back and speak on it as an action item. And we do have a couple other requests to speak on specific items, such as items 4, 5, and 6, I believe. Just know that I have those speaker cards. If you submitted them, we'll get to those as we get to those particular agenda items. The difference, of course, with public comment is we can't act on the items that even if you ask us to take a particular action or try to persuade us just because of California open meeting laws on items that we don't have agendized, we just can't do that. But if you're looking for further information from the administration or from our offices, please say so, and we can do that. We can respond in that way. So, Marcy, you're first up. Thank you for being here.
Thank you. Good morning to you all. I understand the kind of interesting situation here since the item is being held, so I'm actually not going to address the substance of it, although I have some things to say about it.
That's
but
all right.
It's really a logistical issue. The request is to hold this until August 16th, and I would like to request that you specially set either that meeting, the August 16 meeting, or that agenda item to the evening, either of that date or another date, because a lot of people would like to be heard on this item. It's difficult for them to come during the day because they work. I'm a member of PACT, People Acting in Community Together. I don't live on the east side near the Reed-Hillview Airport, but I've met a lot of folks in the work I do with PACT. They feel very strongly, and they would like to be heard. And they understood that this was going to be heard today. We tried to get folks to come today, then said it was going to be held. We've just heard from so many people that how difficult it is for them to come during the day. So we'd request that you, not every meeting, we're not asking you to change all the Hewlett meetings, but for this item or that particular meeting, if you could specially set that for the evening, either on that day or sometime that week or whatever date you want, but to set it in the evening. So that's sort of a logistical request that I have without going into the substance of item 9. Thank you.
Okay, thank you. We'll certainly take that under advisement and try to figure out a way to accommodate all members of the community through the committee scheduling. Next up, Gail, I see you here. Gail Osmer and Scott Largent.
Good morning. My request is also on item 9. I've been talking to a lot of people. There's 2 mobile home parks that are near the airport there. And I have been going out to those 2 mobile home parks on a few different issues in the community. And a lot of those people I found not to be home during the day because they are working. And I am also requesting that meeting for August 16th be at night, be in the evening. I know people that work during the day want it in the evening, so I know it's hard. We're not requesting that every single Hewlett meeting be put or have in the evening, but maybe think about this one coming up for item 9 on August 16th to please have that in the evening, because I also don't live in that area, but it affects a lot of people, and I would like them to have the opportunity to express their concerns and their feelings about the airport. So please consider this. Appreciate your time. Thank you.
Okay, thank you. As I said, we'll take that under advisement. Scott, come on up.
Hi, good morning, everyone. Scott Largent. I spent a couple hours yesterday. I've been multitasking a lot lately, so I got that smaller megaphone that I have now, And since the complaint process that I thought was being rolled out through the PD as far as property was going to actually work for the public, it was just a scam. So what I have to do is I have to go directly to the beat officers out there. And with the megaphone, this is pretty effective out there. I kind of add some humor into it, and I try to get them not to use Courtesy and Meadows Tow. And I've explained what those tow companies are doing, what they continue to do to the poor, the mentally ill, the homeless. Last year we had, I believe, 360 motorhomes were towed in the city of San Jose. Nobody was able to access their property. I met one person that had 3 minutes to get inside of their motorhome and grab every single thing that they own. This is a family that lived in a motorhome that I knew over near Garden City. They were struggling through bad financial times. They owned a moving company. Everything kind of collapsed on them. So now they're living in a van, okay, that they were able to get from a friend, but why would they not be able to access everything they own? Their family history also was lost, their tools, personal possessions, just everything. And they're going through what I'm going through. And as I get more and more lists of people, the city continues to not do anything about it. They're not filling out CHP 180 forms properly. Another example is a form that's a 72-hour notice. All 15 cities use a similar process, and these are supposed to be called into dispatch. Well, when you don't mark the tires and you don't do anything about the actual notice and you don't look into it, nothing really gets done. You can't prove that, you were, the whole get down with the, do you guys even want to pay attention today? Do you guys even care what's happening to the homeless community? Is it more important to look at your goddamn phones? People are losing all of their stuff. These are the people that have it the hardest. This is the reason I come in here all the time. I'm sick of seeing this shit happen, and you guys don't do anything about it. And I keep coming in here, and nobody does anything about it. This same shit happened in the city of San Francisco for the Super Bowl, and we stood on the homeless. We stood on the people that have it the hardest, and we kept taking and taking and taking to make this place look better, okay? And it looks shameful. This is horrible to have happen. And I wish you guys would just pay attention. It's disrespectful to sit on your phones right there. You make enough goddamn money to go do it some other time. Every single one of you is looking down at your phone. And I'm sick of coming into meetings like this. And I see this happen with other members of the public. Is something more important than listening to us? I want to be heard. I should be heard. I shouldn't have to go use a goddamn bullhorn.
Okay, that concludes public comment for today. We will now move to the next item on our agenda, which is item 3, the consent calendar, and any changes to the committee's agenda. Supervisor Wasserman?
Thank you, Chair Cortese. I would make a motion to approve the consent calendar that we have, which is item number 10. I'd also add to that motion to include item number 8, if that's acceptable to you.
Yes, that's acceptable. So we will move a consent calendar that includes items 8 and 10.
Thank you. And I believe in the speaker cards you mentioned you did not have any speakers for 8.
I have none. I have none.
Okay. That confirms it. Thank you.
Moving on to item 4. This is, excuse me, the report from the Department of Planning and Development relating to a draft inclusionary housing ordinance for the Stanford University Community Plan area and provide input and direction regarding policies and concepts contained herein.
Good morning,
Senator.
supervisors, and I'm going to take a moment to open up the matter and then have Mr. Gerard present the specifics of the first ordinance and then the second ordinance when we get to that matter. But first, I'd like to introduce staff. As I said, Mr. Gerard, our planning director, will be speaking, but we also have at the staff table, and I'm going to start on your right, Indra Khalsa with council, and then Elizabeth Pianka is next to her, who is the lead in the general government section, and then to her right is David Dozema, who's our consultant with KMA, and then Consuelo Hernandez from Supportive Housing. And then also in the audience we have Kavitha Kumar from Planning. So what I'd like to do is take a moment to set the table before we discuss these two specific ordinances. You'll recall that we went to the board on May 1st and presented the Nexus study findings the results of our outreach. And then we continued that discussion to the May 8th board meeting. And at that time, there seemed to be some general consensus around some parameters. And we used that to help frame these two proposed ordinances. So with respect to the housing impact fee, there seemed to be some interest in exempting pipeline projects. There was a desire for some phasing of the fee, as well as indexing it over time. And we heard that there was a preference to build rather than collect a fee, and a desire for credits to incentivize building. And with respect to the inclusionary zoning ordinance, I think generally there was less direction there, but really an interest in having a conversation and building a framework for discussion at this committee. And then, as you know, during that May 8th meeting, there was a desire also to have the impact fee discussed here, and so we are doing so. We did present the housing impact fee at Finance Committee last week. And generally, what I would say, there was robust discussion. I think the most significant input we received is that, A, there's a desire to have units built, not so much collect a fee. And then also there seemed to be some openness to the idea that we wouldn't confine building units to the 6-mile radius. So I think there's some general openness and an understanding about whether the rest of the board, has some more refined notions around that particular matter. I want to underscore a point that these are preliminary drafts. They really are intended to start a discussion. They are not, refined and complete, and we are really eager for your input. So, for example, the board did say it was interested in credits. We haven't built that in yet. When we were in our meetings trying to prepare for these two committee meetings, we really were struggling, if you will, about credits and want to engage Stanford in order to have this discussion. And also we're in the final stages of selecting a consultant to help us with this, as well as writing conditions of approval, a housing consultant to be more specific. And so, again, I want to emphasize that this is a starting point. We really are eager for your input. We do have, and frankly, we submitted it last night, so we don't expect you to have read it, but last week Stanford submitted a letter in response to the housing impact fee, and we do have a letter that was prepared. Again, I don't expect you to have read it last night, but we do have David Dozema available if you wanted to have a response to that specific letter from Stanford. And I understand that Stanford submitted last night a letter on the inclusionary zoning ordinance. So with that, I want to turn it over to Mr. Gerard to speak to the specifics of the inclusionary zoning ordinance, since that's the first one up for discussion.
And Sylvia, before we do that, can you, how would you describe for us and, just folks that aren't immersed in this, who are watching the meeting, listening to the meeting right now, the connection between 4 and 5? Items 4 and 5 here on the agenda.
So, for the audience who didn't participate in the prior discussions, in essence, these two ordinances are structured to address affordable housing demand that's created by development on the Stanford campus. And I'll start with the second one. The housing impact fee is intended to address academic space development. And through the Nexus study, we can actually calculate the jobs that are created, the households that are derived from those jobs, and then understand how many of those jobs require some assistance in order to afford living in this valley. And so you take, if you apply a per square foot fee, and the Nexus study showed a maximum of $143.10, you create then a pot or ask them to build the units so that you are not furthering the affordable housing crisis in this valley. Now, with respect to the inclusionary zoning ordinance, in effect, we're saying if you build housing, we want you to set aside some percentage of that for people that require, people who need affordable housing.
All give or take the radius that you were describing earlier, focused on the Stanford geography, because we've been talking about a housing impact nexus study that would extend countywide as well. So I'm just trying to get clear on, you know, I understand we're receiving the reports, we're just giving input, and we're not going to zoom in on very specific actions today. But I'm just trying to make sure that we're clear on the entire backdrop of.
Yes, and so too, I think the question you're asking, you know, the analysis was predicated on a 6-mile radius and the cost because that's a current condition of approval, and until the board changes, you know, policy with respect to that, we started there, but we have done some analysis by KMA to explore if the board were interested in having it constructed, you know, more broadly than the 6-mile radius.
Okay, thank you. Appreciate that.
And so, Mr. Gerard.
So we'll turn to, yes, Mr. Gerard, thank you.
Thank you, Kirk Gerard, Director of Planning and Development. I think it's helpful to discriminate between item 4 and 5, and so that was an important question. When discussions with the full board on mitigating housing impacts, there was 2 types of impacts that were analyzed. If you're creating jobs and building buildings, you're going to be hiring employees. They need housing. So you look at what fraction of housing of those employees need affordable housing. That's the impact fee analysis. The other bucket, if you will, is if people are building housing, then they have a demand for goods and services. And it's the demand for goods and services in the community that has a secondary or indirect impact on affordable housing, so that people that are providing their meals and groceries need a place to live. So you calculate how much indirect impacts. And your board considered 2 options in that second category, those indirect impacts, targeting the housing and charging it a fee per square foot, or requiring that as people build market rate units, they also include affordable units as a part of the market rate construction. Your board indicated you did not want to entertain a housing impact because that could effectively discourage housing construction, but we're interested in the inclusionary housing. That's the topic. That's the first topic.
Yes.
That's right. But Stanford's case, which is here in front of us, was an addendum to the original nexus that said Stanford is proposing new growth at the university. It is going to create direct impacts to housing for their employees and indirect impacts because they're proposing to build housing. So a separate supplement was analyzed to determine the extent of those impacts, and that's the product, or that base study is what gave rise to the product that's in front of you today. These 2 ordinances that would be designed to work in tandem on the Stanford campus. So one thing that I'll say is that the advantage of inclusionary housing program, and most jurisdictions are giving particular attention at inclusionary housing programs as a part of their housing housing policies and programs, are they do create affordable units in concert with market rate. So as you're building market rate units that typically don't satisfy the needs left to market forces to the low income, you're including affordable housing as well. So you're basically matching the demand with the supply. And the second is it provides another source of construction, in that you have private builders doing the work as opposed to nonprofit and governmental agencies actually constructing the units. And so you've got another channel by which you're providing affordable housing. So the proposal in the ordinance is that for market rate development, Stanford proposes 16% of those units would need to be affordable. And there's a certain ratio that they have to be affordable to. That number was derived from the nexus analysis that started with the fact that they're proposing 550 faculty and staff housing units. And if you do the analysis of the income of Stanford employees, it effectively computes to needing about 105 affordable units.
at 16%.
At 16%, you get 105 affordable units. So the ordinance is proposing that ratio. Now, that's convenient. That's within the range that you typically see amongst jurisdictions for inclusionary housing requirements. So I'll go into the details of the ordinance, some of the highlights, some of the policy options and triggers that are built into the ordinance.
Can I just interject one
By all
question
means.
just to see if there's veracity in what I've in the homework that we've done? This would be sort of a, but isn't it true question that Stanford's actually built affordable housing, through the renewals of the GUP or the past, through our past experience with them at a clip greater than 16%. Is that a misnomer or a myth or urban legend, or is that real?
They do build housing. They are occupied by some faculty and staff. They are not deed-restricted affordable units, but the anecdotal information we have is that many of them are offered at below market rates. But they're not classified as affordable units per se because they're not deed restricted, and they don't include the requirement that the tenant is an eligible tenant given the price point of that deed restricted unit.
That's a helpful distinction. Thank you.
They do provide a housing impact fee, which is associated with number 5, but not right now strictly in inclusionary units that would be considered under the definition of the ordinance as affordable housing.
I'm only asking the question because where my mind is going is whether or not the threshold is would actually be memorializing the custom and practice of Stanford and the traditional willingness to provide below market housing, or for in a sense, if the bar is too low in this particular case because we have a developer that's not on a deed restricted basis, but on their own
business plan
exceeding those numbers. So then what do you do? So you don't have to answer that question. It's just that part was just a rhetorical question.
No, I think
why I was asking it. Right. Thank you.
Chair,
Yes.
may I ask a question?
Yes.
Thank you. Kirk, I understand you're going to go into more detail on number 4. I think 5 is really the much bigger elephant in the room.
Yeah.
I don't know how much more detail Chair Cortese needs. I know we have some speakers on item 4. For myself, on the third page of your staff report, the end of the next to last paragraph, it says the 16% requirement noted herein is in line with common practices.
Yeah.
And I think, if I recall, when your staff gave me some briefing, ranges for affordable housing in Santa Clara County cities range from 10% low, I think, to 20% high, perhaps in San Jose. That seems to be the range in Santa Clara County?
That's typical, yes.
Okay. And it seems to me with what you wrote here on the third page, the last sentence, the 16% requirement noted herein is in line with common practice. Is it your staff's recommendation that that is a reasonable percentage?
Yes.
Okay. So Supervisor Cortese,
Let me just clarify. My question was not what the average is in municipalities like you worked at or I worked at, Los Gatos and San Jose. But what's the actual track record in Stanford?
I think your question was a good one.
This geography,
Yeah.
and we set that up earlier when I asked, where are we dialing in here in terms of land use? Is it just Stanford, or are we talking a countywide inclusionary ordinance? So you're talking about a countywide inclusionary ordinance. By all means, we need to be, I think, relatively aligned with our municipal neighbors throughout. I mean, it's another discussion that we're not having today, but I'll interject another thing. There's been some discussion at the board level, and I've certainly brought it up about the possibility of negotiating rather than imposing these numbers with Stanford, a negotiated development agreement. And really, what I'm really getting at is if their pace of creation of below market housing
is greater,
is greater,
I think,
then it becomes very hard to legislate, to your point, at a countywide average or a municipal average when we have a bubble here, a more unique situation. And I don't want to send a message that 16 is enough if their capacity to do more is higher, and they're willing to do more in exchange for other things that we might agree to. So
thank you. I understood what you were asking. I think that was another nice approach to look at. For instance, if they're already building at a 20% rate, why would we say 16? So I think that's a good point. What I was asking was confirmation that what I read here on the third page was in fact what staff found to be a reasonable percentage based on whether the municipalities in Santa Clara County did. And I got that confirmation from you. I appreciate that. I am not certain yet how I want to proceed on what percentage be affordable of their development, and I'm looking forward to hearing from the applicant and the other speakers that we have here today. No offense, always like hearing from you, Kirk. I'm just saying, I think.
And we can go to the speakers to
that's
see
what
if
I would
that
suggest.
helps. If that helps frame the more important issues to focus on in your mind.
Yep.
Absolutely, we do that. We can then come back.
By all means, I could add that we purposely wrote the staff report, so it simply highlights those toggles in the ordinance. So all that is written form. So, yeah.
Great. Thank you. Okay. Well, that's a healthy discussion so far, except for the panel hasn't had a chance to speak at all. We'll hear from the public speakers, and then we'll come back. And, you know, I think one of the advantages of hearing from public speakers in advance is that you have the opportunity of responding to things that we're just hearing unilaterally here at the podium if they raise questions or comments. So Jean McCowan has asked to speak, Karen Hong, Catherine Parker, and then we have some additional speakers on item 5, which we will not be going to yet. Hi. Welcome.
Good morning, Supervisors Cortese and Wasserman. Jean McCown from Stanford University. We very much appreciate your considering Stanford's comments on both items 4 and 5 today, the draft inclusionary ordinance and the draft affordable housing fee ordinance. We totally agree that the region's housing crisis is very serious, and as you know, housing has been and continues to be a priority for the university. Stanford is one of the largest affordable housing providers in the county based on the thousands of affordable housing units we provide and subsidize for our graduate students, combined with about 250 below market rate units we provide for our workforce and other low-income community members. And I would just add one quick thought. Those 250 are deed restricted, making to the point that Kirk made. In our GUP application, we propose to continue adding to that housing stock, both for students and our workforce. You have 2 letters from Stanford. The first, provided last week at the Finance Committee, raises issues with the KMA methodology to calculate the fee for Stanford's proposed academic growth. And the second letter, which we sent in yesterday afternoon, comments on why the inclusionary ordinance is not necessary given the affordable housing Stanford does build and intends to build in the future. You'll hear more about both of those points from others of my colleagues, and we would hope if you have questions, you would put them to us. We also want to speak briefly again about the advantages of working on a development agreement in a collaborative way. I want to make the point that criticizing the fee calculation methodology and questioning the need for the inclusionary ordinance should not be construed in any way as an indication of a less than serious commitment on Stanford's part to make a significant contribution to the creation of affordable housing. We are very interested in having a thoughtful dialogue with you as how to do that in the most effective way. We want to do our fair share and want to find ways to actually get affordable housing built and to do it through a process that gets that housing sooner. Thank you very much.
Okay, thank you for being here.
Good morning, Supervisor Cortese and Supervisor Wasserman. I'm Karen Hong from the Land Use and Environmental Planning team at Stanford.
May I ask Kirk, is it possible to turn the volume up on the, there's a microphone hidden down there, because I don't think people.
Can you hear me now? Okay. The draft ordinance you have before you today requests 16%, and you did have questions about what's our actual track record in comparison to that. I do want to say we should look at the bigger picture and indeed what we have already done and not just what you have in the ordinance draft. So my point is that it's not taking into account the affordable units that we've already been building. Under our current general use permit, when I looked at the numbers, we have built 1,011 net new RENA units. And in your past housing elements, 816 of those have been counted as affordable. And so the county has taken credit for those units in meeting your RHNA allocation. So that's the first point. And when you look at 1,011 and you compare that with 816, that's over 80% affordable. So I hope that does answer your question, Supervisor Cortese. The other point I do want to make is in our proposed general use permit, we've proposed another 900 graduate student beds. Now that would come down to about 450 RHNA apartments. And when you add the 550 faculty staff housing units, that's about a total of 1,000 units. Now we make zero profit on our faculty staff units. We price them to be affordable to our affiliates. But if you look at the percentage, if we don't count any of the faculty staff housing as affordable, 45% of that from the graduate student apartments is still affordable. I see I'm running out of time. I'll just make one last statement.
Please just wrap it up.
Yeah, the draft ordinance as it's presented gives us no credit for the graduate student apartments that we are proposing, and also it's adding on a 16% on top of the large amount of affordable housing that we've already proposed. Thank you for your consideration.
Okay, thank you for being here. Next speaker, please.
Good morning, Supervisors Cortese and Wasserman. I'm Catherine Palter from Stanford University, and I'm here to speak to items 4 and 5. Specifically, I'd like to speak to you about the advantages of working collaboratively on a development agreement in order to bring affordable housing to the community far sooner and more effectively than would occur without such an agreement. Under a fee ordinance or condition of approval, Stanford would contribute affordable housing fees over time as we add academic facilities. Because we think it will take 17 years to complete our academic development, these fees would be metered out over almost 2 decades. In addition, the county would need to wait until sufficient fees are collected to support a housing project in order to disperse the funding to affordable housing developers, resulting in a lag of many years. Similarly, under an inclusionary ordinance, no units would be provided unless and until Stanford builds faculty staff units. The timeline would be uncertain, and the ordinance would create a disincentive to building faculty staff housing. However, through a development agreement, Stanford could front-load affordable housing benefits that are not dependent on the rate of Stanford's academic or housing growth. Under this structure, Stanford and the county could work together to provide needed affordable housing benefits well in advance of any demand for affordable housing from Stanford's 2018 general use permit. Stanford could commit to providing an agreed-upon number of units rather than only paying a fee. We are currently preparing an affordable housing proposal that we expect to be able to share with the county within 2 weeks. We will be offering a specific number of affordable housing units for our lowest paid workers. In addition, we will create a front-loaded fund to develop affordable units in the community quickly. In light of the current housing crisis, we believe there is tremendous benefit to expediting provision of affordable housing units for our workers and in the community. We believe that working with county staff, we can return to you with negotiated deal terms by mid-August. We ask to enter into these negotiations out of a conviction that we share common goals to benefit our communities and that together we can craft solutions that will provide far greater benefits more quickly.
Okay, thank you. Thank you for being here. Appreciate all the speakers today, going all the way back to public comment, showing up and taking the time to help inform us. So we'll go back to the planning department and to the panel, which includes legal counsel and others. Maybe we could have the panel self-introduce first of all. So.
And before they do, I just wanted to offer that they're available to respond to specific questions you have, and principally, Mr. Girard will finish the presentation.
No, it's fine. Thank you. Thank you. It would still be good to have them self-introduce just so everyone in the audience knows who's here, and when we start firing questions off, they'll know who's answering. So maybe we could just start to the left of the panel there, please.
Good afternoon. Good morning. My name is Inder Khalsa. I work for Richards, Watson & Gershon, and I was called in as outside counsel for the county counsel's office.
Elizabeth Pianka, lead deputy county counsel.
David Dozema with Kaiser Marston, the authors of the Nexus study.
Consuelo Hernandez with the Office of Supportive Housing.
Okay, great. Thank you all, and thank you for being here. Back to Mr. Girard.
Yeah, thank you, Kirk Gerard. I'd like to leave the details of the ordinance to your reading. I think if I was to say one thing, it's to clear up the issue about the construction of deed-restricted units versus affordable units. And I don't want to take anything away from Stanford because they have single-handedly satisfied most of our regional housing needs allocation for affordable housing.
Which is what people were referring to as RHNA, for those
That's
who
correct.
don't know what that acronym means.
And the rules for counting a unit affordable under the RHNA framework basically allows jurisdictions to say if it's a certain type of unit, like an apartment, a single family, then you are allowed, if you've established this connection in your housing element, to count that as an affordable unit per se. Now, sometimes that has to be backed up by general rental surveys in your community, but it doesn't mean that the unit complies with the sort of standards that are imposed on affordable units under an inclusionary housing ordinance. And under an inclusionary housing ordinance, there's a lot more standards that a unit must meet for being considered an affordable unit. So it's confusing, but they're just basically a double standard. RHNA, you can qualify a unit per se based on community-wide rental analysis, but affordable units, for example, residents have to income qualify. Usually a certain percentage of them have to be targeted to a specific income level. In the ordinance now, we say generally 16%, but 15% of the affordable units have to be affordable to extremely low or very low income households. 45% can qualify in the low income households, and that's up to 80% of the area median income. And then 40% can be the moderate household that can still qualify. So there's annual reporting requirements and so on. All deed-restricted inclusionary units also count under the appropriate RHNA categories, but you can't, it's not reversible. Not all RHNA units are opposed to those standards. So that is the difference. The 250 units that Jean mentioned, I did not know about, and I think that that's probably a product of the fact that they were constructing them in jurisdictions that require some amount of deed restriction construction. That's not a product of our general use permit. So with that, I'll just answer any questions you might have.
All right. Other questions or comments? Supervisor Wasserman, I just have the same thread in mind to talk about regarding the possibility of trying to negotiate some of these issues out. But let me turn to you first. And
Sure, thank you. And as both our backgrounds, negotiating is totally fine with me. I look forward to, I heard one of the speakers mention they're coming back in a couple of weeks with a proposal. To me, that's all part of the negotiating process. Kirk, what I'm looking at is on the bottom of package page 6, where it says key provisions of the draft inclusionary housing ordinance, that is numbered 1 through 9, carries forward to the next page. These various items that you were just referring to, like 3A, B, and C, that specifically address the 15, 45, 40%, et cetera, that, for me as one supervisor, is very important that that be included in however this item 4 is ultimately constructed. If it's a development agreement, if it's an ordinance, I echo Supervisor Cortese's, there's further negotiation necessary in my mind. And I think we're getting closer. From the beginning, my preference has been more housing, not fees. And each time I've said that, I've seen the Stanford representatives here nod their head. My fellow Supervisor Cortese, I know, looking at more housing, not fees. I said before, we have plenty of money from Measure A to build housing. We don't have opportunities. And so getting the housing, my preference is affordable housing units being built, not dollars paid to us. And whatever that percentage is, whether it's based on what they've done historically, which one of the speakers mentioned was up in the 70-80% range, versus the 16 that we're looking at, maybe there's some percentage in between those two, to Supervisor Cortese's point, that can be negotiated successfully. And then we can get on with, they can get on with building affordable housing sooner than later to help address the needs we have. As Supervisor Simitian would say, on the other hand, this housing is being built for students to come there and use. Okay? I'm a Santa Clara County supervisor. My concern is Santa Clara County residents. So when I think about, for instance, the radius that we get into, the radius question, my first impression is not a big fan of providing affordable housing in San Benito, Alameda County, okay, north of us. So there's particular things that are important to me. What also is important to me is getting as much affordable housing as can be negotiated between us and Stanford, which, to their credit and to your point, have historically provided most of the affordable housing required to meet state requirements. We don't have a lot of housing in the unincorporated areas. Most housing is done in the incorporated. So I'm going to be looking optimistically to the future negotiations, their offer in a couple of weeks, and the continued discussion to get as much as affordable housing as we can. Lastly, to your point, 3A, B, and C I think are very important, where you address extremely low, very low, low, and moderate. One person's definition of affordable housing might be different than another person's definition of affordable housing. And you've listed 3 different levels, and I think that's important that's included. Whether it provides housing for their students, housing for the additional people that will be employed to service the workers, I don't know that, but I think we're headed in the right direction. I feel much better than whatever it was a month ago when we were talking about this before. I think we're getting closer to common ground, and I'll use Supervisor Cortese's term for the last time here, and looking forward to further negotiating this out and getting more affordable housing built in the unincorporated area as soon as possible. Thank you, Supervisor Cortese.
Yeah, thank you for those comments. I think sounds like you and I are, at least in this committee, we're it in this committee, but I've tried to keep up with what discussion's been going on in FGOC up till now as best I can. But speaking for our committee, it seems like we are, if I'm hearing you clearly, Supervisor Wasserman, interested in exploring the possibility in good faith and aggressively in terms of timeline of a negotiated development agreement with Stanford that might, I've just given the one example that has come out in this discussion. They're saying, we've done a ton of affordable units. I think we're in agreement that that has satisfied a lot of the county's RHNA requirement. Although I would say, if it's real affordable housing that's satisfying our RHNA requirement, that's a healthy thing. If it's just a ploy to satisfy our RHNA requirements, that's not good for the general public countywide as well. But putting that aside for a second, I get it with this. That's something we agree on. Whatever they've done, deed restricted or not, we've been able to take advantage of it from the standpoint of satisfying regional housing needs numbers that we're obligated to try to meet. But we have an interest in making sure that those decisions, those market values or below market values aren't reversible. And we could legislate. I don't want staff to take this the wrong way. What I'm going to say next is really something that applies to people in voting positions like us. Sometimes you get to these decisions where it feels a lot more like you're dealing with a meat cleaver than doing microsurgery, because you just have to say, well, boom, 16% is the right number, or some other number is the right number. And I think the value in at least attempting a negotiated development agreement, and they're not uncommon, around municipal specific plans and other areas, is that you can try to get those interests satisfied in a little more nuanced way. At least if we put out there we need, our planning department, our administration says we need to have certainty in terms of the affordability of these units long term. how are you going to make that happen in a negotiated development agreement absent us just applying an inclusionary zone? So if that sets up the discussion, I feel good about embarking on that. I have no reason to believe Stanford isn't serious when they say they can come back by mid-August. We're recessed in July as a board. We're going to be taking up serious business again in mid-August. I know that's a tremendous burden on the administration and planning department to move at that speed. But even if all of you were able to come back and say we've at least negotiated the terms. We don't have we don't have a 40-page agreement or an 80-page agreement or whatever it is, but we have a memorandum of understanding as to what the deal points are by mid-August. It would be encouraging. If you don't, the board of supervisors is sitting here with a lot of good work that we can act on, subject to a little bit of tweaking in terms of an inclusionary ordinance and in terms of a housing impact mitigation fee ordinance. I think the board already signaled that if we do that, it should be at a certain rate, and so I think the backdrop is set, for a negotiation. Do it this way, or give us another way to go in negotiations that satisfies fundamentally the same interests, but works better. I think the upside is, and I'll say this, I know Stanford's here and listening, so I don't want to negotiate from the dais or negotiate on behalf of our good negotiators on staff and council and everything else. But if you're really serious at Stanford about we produce a lot more than 16%, so don't undersell when you put an inclusionary zoning ordinance out here. I would expect a negotiated agreement to come back and memorialize a number that's a historical that is a historical number. I'm not going to put that out there, but I think it's only fair to say if we're going to negotiate an agreement, why would we at the county agree to a negotiated agreement at 16%? We can just impose that right now. What I'm hearing, the dangling carrot for us is we do more, we can do more, but we'd like to establish that number in a collaborative way. So it's a good, I guess what I'm saying, all things considered, it's as good a time a year, it's a good a time as any, I think, subject to, one of you telling me otherwise, to give it a try. And I think it's a little more in a couple weeks. I mean, it's a relatively short time to say mid-August. It's barely over 6 weeks. But sometimes things move fast in a 6-week negotiation when people know what it is they want and they're dealing in good faith and they're making themselves available. And in this case, a lot of foundational work, I guess what I'm saying, there's just a lot of foundational work already done. On page 4 of 7, it really starts on 3 of 7, but key provisions of a draft inclusionary ordinance, I mean, really sets out a beginning point position for what it is we're looking for, at least on item 4. And that's a lot of work already done. It's not as if we would be saying, go out and clear the whiteboard and start all over again. And, we've never talked to these folks. We've never thought about this. So you kind of have what we used to call at Fremont Drag Strip when it used to exist, a running start. So, a rolling start is what we used to call a rolling start. So Supervisor Wasserman, that's my input. And
Thank you.
It sounds similar to yours, but I want to make sure that
I like that direction. I echo that direction. I have one question through the chair to our council, if I may.
Yes, please.
Thank you. Elizabeth, question to you. On this particular item, one of the notes I had was the negotiated development agreement versus an ordinance. I know I want more housing than fees. I want to go that way. They were referencing a much higher percentage of the units that they build being affordable. One of the concerns we've expressed is different levels of affordability. The whole idea of negotiating, I echo what Supervisor Cortese said. the value from your legal perspective, ongoing, ordinance versus development agreement. In my mind, development agreement would apply to this one thing, this one project, this one GUP area. Ordinance would be more all-inclusive, all-encompassing. Can you help me understand as far as what direction, what's benefits, pluses, and minuses?
The ordinance, the two ordinances that are before you, Elizabeth Pianka, Lead Deputy County Counsel, the two ordinances that are before you, both the inclusionary housing ordinance and the impact fee ordinance, are applicable to Stanford lands regardless of the existence of a general use permit. A development agreement would exist specifically for the proposed 2018 general use permit. With an ordinance, with the impact fee ordinance, we're governed by the standards of the Mitigation Fee Act, and with the inclusionary housing ordinance, we're governed by various standards that are set out by case law. With a development agreement, there's more flexibility in terms of methods to acquire affordable housing that are outside of the parameters that govern the ordinances.
Okay, thank you. I appreciate that. And Supervisor Cortez, I don't know what your intention is. To me, it seems like we've gotten to a point as far as direction regarding item number 4. I think 5 is a separate matter.
It is, but it, of course, may end up with a similar disposition.
Yes.
But we have speakers on 5, and in any case, we need to hear speakers. Why don't we just act
Would you like on 4?
4. I'm suggesting, and let me back up a minute. Maybe I need to ask a question. I'm not abundantly clear on whether FGOC gave any direction that was very specific, but I mean, we have our subject matter jurisdiction here. This is before us today, so we can make our recommendation, but I want to make sure that staff is comfortable going out and, doing work that the committee is asking to do and bring back. One of the things I want to know about FGOC is, have they asked for a report back, period, as opposed to going to the board back, just going back to the Board of Supervisors, because that would have some bearing on how we make a motion.
My recollection is that they didn't seek specifically direction to report back. They are interested in the discussion taking place here, and I think generally we're expecting that based on the input of both committees that some sort of framework would be presented to the board in August.
Great, that's very helpful. I'm trying to keep from delaying once we have what we want in terms of work product done, delaying. I don't even remember when the committee meets relative to the board in August. Going to the board after you've done some work for 6 weeks directly without having a check-in just to say, great, looks good, let's get it to the board, sometimes is a little, I'm sure is a little nerve-wracking, for lack of a better way to put it. So if there was a ability to stop here just to get some feedback, yes, we think it's close enough to get it back to the board with some kind of a recommendation from us. That would be nice. And I apologize, I don't have all those dates in front of me.
If I may, our next Hewlett meeting is August 16th. Our board meeting will be the week before that, roughly speaking.
There's a meeting on August 14th, but also a meeting on August 28th, and our intent was to return August 28th. So let me sort of expand on the comments that you all made and provide some more context. Generally, a development agreement is negotiated in the context of an actual application, which is not before this committee today. The board did authorize, as you know, the general ability to engage in discussions for development agreement. It would take effect at the end of July. One of the challenges is that we do need an application from them expressing their interest into engaging this. But also we need some direction from the board that they are interested in engaging in a process by which we could negotiate a development agreement. There are a number of other benefits beyond conditions of approval and, to mitigate the impacts from that development that potentially could be incorporated in. But we really won't know this until we prepare sort of our final draft conditions of approval, and then we can see, what may be of interest to the board beyond what we can incorporate into, those conditions of approval. And so we don't have authority from the board to, enter into a development agreement. And, I think that would be a necessary step to understand both the scope of that, if the board has some notions of what benefits it is interested in. And I'm not sure that the board has given that thought beyond affordable housing. But what I am hearing from this committee is that in lieu of lawmaking, which Ms. Pianka indicated is something that would apply until you decide not to apply it, as opposed to this discrete application, that's a very significant, policy discussion. And I'm not sure that the board is of one mind with respect to that. And I think Mr. Gerard has some comments as well to.
Let me just say, what our comments aren't leading to, go finalize a development agreement. That's why first of all, I don't think that's possible in 6 weeks. I know the board authorized as a whole on Tuesday the tool, and so Stanford is. I don't know what more they need to do in terms of paperwork. Mr. Gerard, the attorneys would have to tell us that. Your point's well taken that they would need to trigger that process, and there's probably something, including a possible check that needs to be written, but something has to be done to trigger that process on their side. We can't force them to enter negotiations, but they're sending emails and showing up here at the meeting, and they started this conversation at the board meeting in May, as I recall, saying we'd be interested in that. So I think it's safe to assume they're willing to to step into that kind of a negotiation and file whatever paperwork needs to happen to trigger that. What I was really getting at is that on the committee's jurisdiction, assuming that Stanford is willing to utilize that tool that we approved on Tuesday, to trigger that process, it seems to me, and the board has approved that process, so we have that authority taken care of, that we, at least at a committee, can say, go explore what a development agreement with them would look like, begin those negotiations, whether you want to call them preliminary negotiations or something else, without expectation, as I said earlier, that you'd be coming back with, a multi-page contract ready, to execute or for delegation. That I think needs some more guidance from the full board before, people on both sides perhaps waste a lot of time and there's not 3 or more votes to approve something like that. So I think this is, there's going to have to be a little bit of iteration, and I'm hearing you, but I also we're here, and I don't want to squander the opportunity over the next few weeks to get some work done with a willing party. And again, it just seems that the table is set to move into to move forward on negotiations if indeed that's authorized by the board or the committee. I'm just hanging my hat on the fact that the Board of Supervisors, I'm hanging my hat on the fact the Board of Supervisors approved that tool, knowing full well that once we approved it, there's a process for somebody to, an applicant, as you say, to open that process up. But again, let me just say one more thing, Sylvia. If we didn't have, I understand you also need negotiating guidance, as in some authority to go back and forth, give and take. But we have, what I was trying to say is I'm fine, as at least as this committee, saying that our starting point for those discussions, those preliminary negotiations, should be what's before us today. combined with what the board, especially on the impact fee side, I'm jumping ahead to item 5, has already identified as a number. I feel, I don't know, Supervisor Wasserman, if you agree that we're well within Tuesday's approval and what our colleagues have previously said, to wade into a negotiation saying this inclusionary ordinance is what, with some modification, is what we would expect to submit to the board absent a negotiated agreement. This impact fee ordinance is what we would go back to the board with absent, subject to some modification, but absent a negotiated agreement. It's their turn to hit the ball over the net and say, we have an alternative to that. That's what I'd like to see done in the next few weeks, which would then allow you to do some analysis on how much do you recommend that we keep those negotiations going and we try to come to an agreement. So I'm sorry I can only look one direction at a time, but I'm trying to talk to all of you. Are we within the chalk lines if we do that, just in terms of jurisdiction here?
I just want to say, hit the ball over the net, rolling start within the chalk lines. So here at ESPN.
After all this,
I've got a comment. I'd like to do it after Mr. Girard.
Okay, I think what I seized on was your direction saying, please negotiate the terms given Stanford's proposal to submit a plan, and I think that the plans they submit would help determine what the appropriate path is, either to continue on a lawmaking path, potentially incorporating their plan into that vehicle, or if the elements of the plan suggest they'd be better achieved through a development agreement, then pursue a development agreement. But that's really a separate issue. Which vehicle the terms are carried forward in is different than the terms, right? The public is not going to know whether or not those houses were built in the context of an ordinance or a development agreement. And the merits of one path over the other can be separated from the terms themselves. So we can come back to the full board and say, here are the terms given the plan that Stanford has proposed, and potentially a recommendation of whether we would effectively stay the ordinance process and then transfer over to the GUP path and a development agreement, because that would be the distinction that the board would, and the decision that the board would have to make, right. Or stay the course on an ordinance path. I think that's what we could potentially get done by August.
And so, this is where, Wasserman, I know you've asked before, but my intention on direction would be essentially to say bring 4 and 5 back to the committee, as well as any progress around a negotiated development agreement to date, prior to the August 28th board meeting. It would essentially be that would be the sort of the simplicity of the motion. All assuming that Stanford follows through and submits an application. Supervisor.
Thank you. I think what you just said there at the end is that we bring this item back to Hewlett on our August 16th meeting with the hope that the offer from Stanford will have come in, negotiations will have gone back and forth, and I'll direct this question to Elizabeth. I assume any negotiations that have taken place prior to coming to the committee, prior to going to the board for final decision, would be non-binding to us in any way until we approve it. I mean, both parties have to sign off.
Correct.
Okay, thank you. So, Supervisor, if your recommendation was that we bring, and again, we're talking about item number 4 now, and we may come to the same conclusion, or perhaps we lump in 5. I'm open to your thoughts on that as well.
I think we do, actually.
But at this point, we've heard from Stanford that they're going to bring back something in a couple of weeks to staff. I think we've given direction to negotiate. I agree with you that the items listed, and I'll direct this to Kirk and Sylvia, the items listed on package pages 3 and 4 of 7 are very important to us as well. Whether that comes back with your recommendation that it be a development agreement or an ordinance, I'm interested to see that. But I believe if we can hear it on August 16th at Hewlett and then forward with our recommendation at that time to the board for August 28th. And I believe that's what you effectively said a few minutes ago.
Right. So at a minimum, we know the work that's before us today in 4 and 5 will be ready to go on the 16th, but we don't know how much progress would be made on a development agreement. But
with all these exceptional people, I'm sure there'll be exceptional progress.
We,
So that's a motion if you like it.
I will second that.
Or you make it and I'll second, whatever you like.
No,
And
it's
it's 4
fine.
and 5?
4, and I think we should just include 4 and 5 to save the going through this attempted motion again. But let me just stop for a moment before we formalize an announcement that we've adopted any kind of direction, and ask the speakers who asked to speak on item 5 if they'd still like to speak, and if so, to come on up. That would be Jessica Von Bork, Gene Snyder, and Catherine Palter said she was speaking on 4 and 5, but if you'd like to, this is obviously open government rules. You've asked to speak on both. Our published rules say that you can if you want to, and that's just fine. But you hear where we're going, and please come on up. You have a couple minutes each to speak if you choose to.
Yeah, thank you. Catherine Palter again from Stanford University. And I think given in light of your motion, we're happy to just not make any more public comments to item 5.
Okay, thank you. So I'm taking it that the others are passing. And if we're in agreement then, and there's no red flags or objections from staff to including 4 and 5 in one motion, then we'll go ahead and take the motion as applying to both. And it is adopted unanimously then. Thank you. That's the direction, and we'll look forward to picking it up in mid-August. Item 6 is next. This is Phase 2 Alviso Dock Feasibility Study, a bathymetric survey report.
Good morning.
Morning.
Just by way of introduction, making their way up to the staff desk are Annie Thompson, our principal planner, Sharice Orange, one of the planners in the department, and Greg Milo, who was the principal project lead with the consultant team for this project. And they have a presentation that they'd like to make, if that would be helpful for the committee, and then we're happy to answer any questions you've got.
Great, thank you. And we've read the materials, but if you can highlight what we've determined, that would be great. And we do have, I should mention, we have a couple public speakers, and I will call upon you after we've heard the presentation. Thank you.
Good morning, supervisors. My name is Sharice Orange, Associate Planner with County Parks. This morning, we are here to present the conclusions of the bathymetric survey study performed on Alviso Slough. So just a bit of background. In August 2015, members of the public asked the county to consider rebuilding and managing an existing privately owned dock in Alviso. The county determined that a feasibility study was needed to assess that possibility, and in June 2016, funding was allocated. Last year, County Parks presented to Hewlett the original feasibility study, now known as Phase 1. The original feasibility study was developed using only existing file information. It was unclear the extent to which dredging was likely needed, as no new studies of the slough's physical conditions were completed. The bathymetric survey study, now known as Phase 2, evaluated the slough's physical condition. The study also incorporates assumptions based on guidelines that were deemed appropriate for the project site. Our consultant, Greg Milo from Trans-Systems, will present those findings later in the presentation. The potential dock project is located approximately a half a mile south of the Alviso Marina County Park boat launch ramp. The potential dock is delineated in the yellow hash marks. When fully functioning, there were 50 slips in operation. Today, only 8 slips remain due to sedimentation buildup within Alviso Slough. There are several leases and owners within the project site, including State Lands Commission, the Santa Clara Valley Water District, and other private owners. Here is the schematic that was provided to County Parks in 2015 by the public. You'll see in green, it shows the existing docks, and in red is the proposed dock alignment. You can also see that the new dock alignment would be within the channel. And here we have an aerial view of the docks and vessels to be removed in green and the proposed dock project in red. Now our consultant, Greg Milo, will present the bathymetric survey methodology and results.
Thank you, Sharice. Good morning, everybody. Just following on to what Sharice said, just give you a brief background on the study methodology. The phase 2 of this study developed some hydrographic bathymetric information of the slough and the project area. And we used various methods of hydrographic survey to characterize the conditions of the slough bottom and the slough banks from the mouth of the bay back to the Gold Street Bridge, so a little over 4 miles of slough. And based on that information, we proceeded on and developed some assumptions that were basically laid out in the phase 1 report. And in more detail, we've based the assumptions on recognized guidelines from the state of California Parks and Recreation Division, Boating and Waterways, that have been being used for quite some time. The details that led us to the conclusions and the numbers that we provided as far as the amount of work and the cost of the work involved is based on a 50-foot channel bottom width, which is a little less than the Boating and Waterways guidelines, but considering the confines of the slough and the wetlands and levees that are adjacent to the slough, it would be difficult to increase the width of the slough much more than that at the bottom depth. This includes, we've assumed that 35-foot maximum vessel size, in that range anyway, which would have various drafts of, there are a lot of shallow draft boats that are being used in the area, and up to a boat of this size, probably anywhere in the range from 1 to about 3 feet of water depth is required to support those boats in the slough. And the lowest observed tide in the slough historically is just under -2 feet mean low or low water. And so based on the guidelines, we are 5 feet below that to allow for adequate water depth for the hulls of the boats that would be expected to use the area. And this, again, based on the state guidelines.
Excuse me, let me interject a question. That's assuming you want 7-day-a-week access. Is that what you're saying, or are you still taking into account off days because of tidal fluctuation?
I'm sorry, I couldn't hear what you said.
When you say that the lowest, the mean low water level was minus, and therefore in order to allow for the draft for these vessel sizes, you would need to dredge below that, right, to get to the number that you wanted. Are you contemplating having enough draft for continuous operation at all times, or just fluctuating with the tides?
At all
off
times.
days, on days, and so forth.
And the conditions are, certainly at higher tide levels, there's not an issue. But the conditions for the slough and a project of this nature need to be such that the county has the knowledge that at any tide level, which could happen any time during the day as the tide cycles change over the throughout each year and through the decades, the tidal cycles move throughout the day, so you can have low tides anytime during the day and night. And we generally would want to have the design, a good design would recognize that even at the lowest observed tides, we would still have adequate water depth for the deepest draft boat that could potentially be in the area. And so,
yeah, so thank you. You actually understood my question exactly, and you answered it, I guess. And so my follow-up question is, have we done any calculations other than that, based on that premise of what you just described, essentially ongoing, I don't want to say 24/7, but use irrespective of tidal fluctuations? My understanding is that we have tidal fluctuations that temporarily shut down harbors and docks, up and down the coast. As nearby as Santa Cruz Harbor, they can't go in and out of there 7 days a week. Also, in some cases, because of siltation issues and so forth, but they still get quite a bit of use out of it. We can't go in and out of the slough as it is from our marina right now 7 days a week from the point of the boat slip, but people get quite a bit of use out of it. So I'm just wondering where on the continuum really is acceptable. Your premise is the only thing that would be acceptable would be, constant, continuous ability to use it. But is there something short of that we should be looking at as well?
Well, the assumptions that we made are based on a conservative approach that would provide accepted adequate conditions at any tide level. Of course, as you know, the slough is in constant use now, and in general, people at the South Bay Yacht Club that have been there for quite a long time, been using that facility for a long time, very experienced boaters, know the tides, and know the limitations of the navigation within the slough and the dock area. I have a couple of slides that depict conditions at a less conservative depth than this design, but they kind of show that it's like, why is it useful now for certain constituents, and why does the county want to, or the department, we're working on this thing, we need to put forth the facts in such a way that we have a comfort level that even inexperienced boaters that are coming in for the first time, or that may not be really oriented to tidal situations and things, that we don't have somebody run aground in some of the high spots that are in the slough. So we took a look at that at an elevation of a couple of feet higher than this low tide, which would be at those conditions would provide, say, 2 feet or up to 4 feet of water in most places. But there's still some high spots that we've highlighted that an experienced boater that uses the slough would know. Let's keep to the right, or let's keep to the left, or let's be careful in this area because we know it's shallow. But the inexperienced user of the slough wouldn't know those things.
Well, so first of all, I don't want to imply that you've done anything wrong in terms of the approach that you've taken and the sort of the project that you're describing. It's a $21 million price tag, and I'm just trying to figure out if there's a marginal utility value short of doing $21 million worth of work that improves upon the current conditions, but doesn't necessarily go to this gold standard, if you will. I don't know how else to describe it. The standard that you're describing, which is, I hear you arguing that for a county agency, it should be the minimum standard because of boater sophistication. I have a little trouble with that because I'm not understanding that once you get past the marina that we're doing anything different. This is just a segment leading up to our boat slip that we're studying. Beyond that, it seems to me you still have to have boater sophistication because those tides I mean, we're out there all the time. You can't even kayak out there at certain times, you know, from the marina on out to the bay for that 3-mile stretch. So don't you still need navigation sophistication and boater sophistication to deal with it, irrespective of what you do with this segment, you know, to get out to the bay?
Well, in general, the slough is used by, as you know, a lot of non-motorized watercraft, kayaks and such that are very shallow draft. They're not going to have an issue with most of those areas at any tide level. What started this study was a project that would incorporate approximately 18 boat berths or slips in the slough area, and those boats we're assuming those are likely to be somewhere in the range of up to 35 feet or so in length, and would have a draft in the water, a depth of the hull in the water of probably 2 to 3 feet, unless they were sailboats, which could have even a deeper draft into the water. So in order to prepare the study and the analysis based on that project, we have to assume that those types of boats would be in the slough potentially at any time, and potentially at the low tide events that happen occasionally. And as a matter of fact, we're using this -1.8 as that's the lowest observed tide. I checked the predicted tides, which are, you know, the anticipated tides that can still change with atmospheric conditions, but the predicted tides are generally about once per month you would have a -1 tide in that slough. So we're only slightly lower than what would in this low tide situation would occur infrequently, but once a month at least there would be a -1 tide in that slough, and there are some high areas in there that would potentially impact certain vessels.
Okay, I understand. I was trying to establish what assumptions you used and whether or not you had any alternative assumptions that you used that you haven't presented that would give us either different cost figures or different project scope figures. And that's not a setup for criticism. I'm just trying to understand what you only can do, what we charge you to do, and what we contract with you to do, and then come back. And what I'm hearing is if we wanted something that was in between the current capacity of the slough and what you're describing, we would have to go back to you and say, you know, factor in these other assumptions. Is that fair enough?
Supervisor,
It's a different job.
I just wanted to interject because I think I understood a couple of the questions in there. I might be able to help answer them.
Sure.
So one is that this bathymetric survey did look at the entire length of the slough. So the estimate of the $21 million includes dredging in the area around the existing dock and all the way out to the bay. So that's the entire length. If you were to dredge only in the area of the dock, that number is also included in the survey or in our report. And it's much less expensive, obviously, because you don't have to dredge the full distance.
What is that number?
I don't recall.
I'm sorry, what?
16? Sorry.
The dock area, in order to build the dock that was shown as the project, would require about 16,000 cubic yards of material to be removed to basically widen the area. It basically takes the South Bay Yacht Club's proposed sketch that they had originally, moves it slightly inland toward the bank to allow more water, more width in the slough. But there's and I've got a cross section here as well that shows a wedge of material about 16,000 cubic yards for just to do that part, irrespective of the rest of the slough.
Right, and I'm the one who brought forward the referral, the request, and that was the scope that we were looking for. We were asked a very simple, more simple project question than this longer cost out that you've done. Not that that's bad information. It's great
So-
to have it, which was, hey, if we wanted to make greater use of the dock, it seemingly we could move it over. What would that require in terms of dredging and so forth to increase navigability, turnaround, there? I mean, just obviously, if you're in the middle of siltation and weeds and so forth, and from here to the other side of the board chambers, there's water depth. There's a natural human nature to say, what would it take us to just do that, just to get over there?
So-
And that we were, it was brought back to us and said, we don't know. We're going to have to do this study. So I appreciate your clarification that you've actually, I didn't pick up on that, and that's probably absolutely my fault, not your fault. I just wanted you to know I'm glad you heard my question and that you're saying the information is here on sort of the almost like a bifurcated project.
Right. So we looked at both, and in the cost estimates in the report, which we don't have in the presentation, I think that area was $6.7 million estimated cost. Is that correct?
Yeah,
Greg?
if the project estimates that we did, and it's alternative 2B, the large estimate included the dock project and dredging as well as the slough dredging. And that was, I think the overall was like 21 million or whatever.
Right.
We removed the line item for the slough dredging and just left everything else the same, which would be the project with all the landside amenities, but the project area plus the dredging for the project area, left that in, and that's what Annie says, it drops it down to $5 to $6 million overall.
Can you show us the slide of the dredging just in that area with the section view? I think that might be helpful.
Yeah, we had, in the packet, what jumped out at me in bold literally was, three alternatives that range from 12 million to 21 million. I didn't see a 6 million, but again, I'm probably not reading closely enough.
Supervisor Cortese? If you look at the actual report, it's on page 20 of the report. Sorry, I don't have the packet page number, but.
Okay, that's where the breakdown is of.
Yeah, it's embedded in the table.
I see it, yes, you have a table 1 here.
Mm-hmm.
Okay, great. Thank you for pointing that out.
And to clarify another point that I think might be helpful, the Department or Division of Boating and Waterways standards, we actually stayed, as Greg was saying, less conservative than what those are on the width. So the channel bottom width in the area of the dock would be expected in their standards, which would be what we would use if we were, for example, seeking grant funding from Division of Boating and Waterways. They would be looking for a 75-foot channel width for this type of a facility. So we actually didn't go quite to the gold standard, as you mentioned earlier, and took a little more conservative view, at least on the width. And this cost estimate is for only the 50-foot channel bottom width.
And what, and how binding are those guidelines? I did read about those here, so.
Yeah, they're not
one of my
binding.
questions, whether or not it matters if we're right on their guideline recommendations, or if they're somehow, I get it about any grant funding that requires their sign off would require meeting the guidelines. But other than that, are there any legal constraints legislative constraints that they bring to bear on us?
No.
Okay, great, thank you. All right, helpful. Helpful. I'm getting a better picture here. And I don't want to tie you folks up all morning, or my colleague here, Supervisor Wasserman, but it's been helpful to have the discussion so far. So let me just ask you to continue along. And
Supervisor Cortese?
Yeah.
Could I interject? Maybe I wanted to ask a follow-up question that I think might get some information you were getting at. I think what I heard you saying was, would it be possible for us to sort of explain, based on the bathymetric survey, what the draft of the boat during different periods of time would be, sort of the minimum draft would be, and so that you might understand that, 5 or 6 times a month during tides below a certain level, you could only have a boat with a draft of 2 feet or a boat draft of 1 foot. And I think we probably could, based on the information we have, produce that sort of analysis. If you wanted to say, I'm only interested in boats of up to 20 feet being able to get through medium tides or above. We can tell you how often that is or something like that.
I'm trying to get the two outcomes, and if it requires, if it would be helpful, you have a great thorough report here as it is, but to come back, one more time and talk to us again. What I would be interested in is that, which you just described, and also interested in trying to figure out what the, I'm full of metaphors and analogies today, but the old one is Cadillac and the Volkswagen, right? There's value, utility value to having a more minimalist project around the dock itself, which doesn't attempt to get us all the way 3 miles out to the bay, but allows maneuverability in that area, subject to knowing what the guidelines are, but subject to what we think would be, the minimum amount of work you would do for it to be useful at all. Secondly, what you're describing, and then how deep do we really need to go with the dredging if we're trying to double the usefulness that we have right now versus, I'm just throwing that out there, versus getting this on all the time kind of use out of it. And lastly, I'm trying to come up with a number so that we can pursue grant funding at the state and federal level, whether it's parks bond money, if we can qualify for that. We have lobbyists in DC that are asking us all the time, can we, track down grants for you? I've been out there and talked to Maritime in the past, and they've said, there's grants that depend on port status, which we don't have. There's others that don't. But I mean, you can't really go have a serious conversation with anyone or government affairs folks without having, I don't want them asking for $6 million if we absolutely really should be asking for $21 million conceptually, subject to 1 million approvals, right, by Army Corps and BCDC and everyone else. So it's hard to have that conversation without dialing in a little bit more. So that's what I would, characterize as what I'd be looking for. The bottom range and the top range. You have a lot of that information here that you've pointed out. But.
Well, and I think, Greg, can you show us the slide with the red and blue SLU? One of the things that we looked at, what Greg was mentioning, was a more conservative view just for our understanding of if there were a lesser project. We did not do cost estimates on this, right?
Beg your pardon?
We did not do cost estimates on this depth.
No.
But this is the more conservative look. So we could easily provide cost estimates on this. And it really would more mean dredging in the high spots. So this is only the -4 versus the -6.8 that the report looked at. So we absolutely have already honed in on this information, and the graphics are really helpful for seeing where those high spots really are in the SLU and in the area around the dock. We could look at, again, the breakdown of just the dock area versus the SLU if that was helpful.
Okay, it would be helpful. Why don't we do this? Let me go to public comment and see if there's anything that needs to be addressed that's just brought up by the speakers who have requested time to speak today, and come back and maybe what we do, at the risk of sounding like we're not interested in hearing any more from the consultant. That isn't the point here, but rather to come back and zoom in a little bit more on the questions that have been raised. And I appreciate Mr. Courtney's characterization of what would be helpful in terms of additional information as well. What you just dialed in on this would be very helpful to me to understand, again, just from a cost standpoint, if nothing else. Let me go to the speakers: Russ Robinson, Roy Hayes, Eileen McLaughlin, and Mackenzie Mossing. You'll have a couple minutes each.
Good morning. For the record, my name is Russ Robinson. I'm the staff commodore at the South Bay Yacht Club in Alviso. Before I get started, first let me wish Rob Courtney a happy and productive retirement. When Rob first came on board, I met with him and I said, what can I do for you? And he said, what? Everybody asks me for something. So I hope that I've been able to provide some support, and that offer goes for your replacement as well. Comments on the bathymetric study. First of all, the report is very, very excellent. It adds a lot of knowledge to what we have out there in the slough. It supports what we've found on our own tentative surveys by boaters that we have. One was done by a member of the Power Squadron who carries a 100-ton master's license. He was very accurate in what he did. And of course, we have the fishermen, the shrimpers that go in and out all the time. I understand that when the county launch ramp was designed, there was no need to do a bathymetric study, and so this is added to that information, but it was not felt necessary then, and probably it only adds to our information, but it's not a deal breaker as far as I can see. The launch ramp has been accommodating various sizes of boats for quite some time with not much problem. Some people run aground, but that's because they get out of the channel, and that's not the problem of the county or anyone else to try to protect for that. A deep draft boat, like a sailboat, is a wonderful depth finder. You'll run aground, and I've done it myself in the Delta. May I have some
Just go ahead and, if you can wrap up in a couple sentences, Russ.
In the Delta, there's over 1,000 miles of navigable waterways. There are high spots in that, and people find them all the time, but they are not things that are dangerous. This is not a rocky bottom here. It's all mud, and people can get through it.
I'm going to need you to wrap up. I'm sorry.
Yeah, sure.
And you're more than happy to submit notes to us, to the clerk, if you have them.
The report from the Department of Boating and Waterways are specifically guidelines. I've been into many, many marinas where they have been involved, and they do not follow that guideline.
We understand that. I'm going to ask you to stop, Russ, because otherwise I have to expand everybody's time.
Okay.
Yeah, unfortunately, your time's up. So
I will submit a written report.
Absolutely. Please do so.
That'll do.
Thank you for being here, and we appreciate your comments.
Thank you.
Next speaker, please.
Good morning. My name is Roy Hayes. I'm with the South Bay Yacht Club. A couple of things. I know the county just purchased a very large catamaran boat for providing educational studies on the South Bay and on the Alviso Slough, and that thing is at least 40 feet long, and it's very wide, and it's going to be in and out of the boat ramp, and a dock would make your life much easier launching that boat. Just FYI. Also, just a matter of course, we've had 2 inquiries for dock space in the last month at the Yacht Club. And also, if in fact you were to consider dredging the entire channel, the Santa Clara Valley Water District is in the process of increasing the size of the levee. They're going to bring 100 trucks per day of fill through the town of Alviso, and it would be to everyone's benefit if some of that fill came out of the slough, and it could be mixed with the fill, and the engineering would work to raise the levee as part of the South Bay, I think it's called the Restoration Project. And all you need to do is get stuck out there once, and you learn your lesson. I've done it a couple of times, but I have learned my lesson. That's it. Thank you.
Oh, thank you. Next speaker, please. Hi.
I'm Eileen McLaughlin. I represent the Citizens Committee to Complete the Refuge, and I provided a paper map. I hope that you have a chance to look at that. I want to look at how history is telling about this project. You have an 1850s era map showing Alviso, where the Guadalupe River, as it splits into 2 forks, Guadalupe Slough and Alviso Slough. At high water, if you look at all the marshes that are around there, at high water, the water and sediment spread out along the entire shoreline. The Port of Alviso thrived in saltwater conditions. The South Bay Yacht Club and its marina attracted use. This is all into the early part of the 1900s. Then the salt ponds were built. One fork of the Guadalupe Slough was cut off. Of the Guadalupe River drainage was cut off. That's the Guadalupe Slough. All the open marshlands were cut off. The entire Guadalupe watershed, water and sediment, was diverted to the channel that is Alviso Slough today. Port of Alviso disappeared as fresh water and its attendant tule grasses clogged the channel with sediment. The marina silted and does still. Actions of the 20th century completely changed the hydrology, and we are forced to live with it. The Salt Pond Project may change the degree of scour if given decades. Sea level rise may change the entire shoreline by the end of the century. Maybe then a really good marina could be built. We can reminisce about what was there. We have to live with the reality of what is there. We are concerned that this would move forward without those considerations. We recommend this project be terminated. Thank you.
Excuse me, through the chair.
Yes, Supervisor.
What organization were you with?
Citizens Committee to Complete the Refuge. We work with the Don Edwards.
Citizens Committee to complete what?
The Refuge.
Thank you.
We work with the Don Edwards Refuge.
Okay, great. Thank you. Next speaker.
Good morning, supervisors. My name is Mackenzie Mossing. I'm speaking on behalf of the Santa Clara Valley Audubon Society. Many of our members visit the Alviso wetlands to enjoy wildlife viewing and bird watching. There's an abundance of shorebirds that migrate and congregate in that area. Additionally, our Wetlands Discovery Program, which we offer to elementary school students, we bring children out to those wetlands so that they can learn about the wetland ecosystem and the birds and wildlife that rely so heavily on these sensitive habitats. For these reasons, we are greatly concerned that with any project that could impact the bay and surrounding sensitive ecosystems. According to the staff presentation, the proposed Alviso dock will require dredging, wetland take, and vegetation removal in a sensitive wetland habitat. This study did not analyze likely impacts to the Don Edwards Wildlife Refuge nor the neighboring salt ponds, but we can expect these impacts to be significant. The report also does not take into account mitigation costs that could arise from this project, which we could also anticipate to be significant. With an estimated 21 million capital costs and annual operating costs of $2 million, please ask yourselves, do the benefits outweigh the costs, both fiscal and environmental? Certainly they do not. Please protect our baylands, our birds, and our wildlife, and do not proceed any further with this project. Thank you.
Okay, thank you again to all the speakers. Supervisor Washburn, let me just turn to you. You heard the questions that I asked that I'd like to get a little more information about options, especially at sort of the lower end of the cost spectrum here, as well as some of the information in terms of utilization of the slough at something less than 24/7. So I'd like to just ask that we suspend the discussion for today and ask for that information to come back. I'll turn to Mr. Courtney and say, what would your department be comfortable with? August, September? Sharice, do you know? I'm sorry. Anyway,
I'm not sure I can give you an answer right here at this moment, but we could caucus afterwards and might take some further discussions about how the contract would have to be amended and things to bring back the information that you're seeking. So
if you can just close that loop with us late summer, early fall, so that you have the time to figure out what it takes to go get the answers to those questions, that would be great. And let me know as the chair when it's ready to bring back to the agenda, or let us know at the committee we can put a placeholder on it at some point if we need to. If that meets your satisfaction?
That is fine. I've learned a great deal the last couple of times that I've received reports from the consultant and from just learning about the catamaran, just learning about the new boat. Also learning about what I would call running aground. I don't know the exact nautical term for it. The bottom of your ship runs into the mud. I enjoyed the speaker who says, you learn once, he's done it twice, but he's learned. I, for one, don't understand, and I'm looking forward to hearing on the report back, if you build something and sometimes during the day it can be used and sometimes during the day it can't, you drift a little out of the center, you're in trouble, and I'm looking forward to learning what that means you're in trouble. If you're there, are you blocking the ingress, egress of others? So I'm looking forward to the answers to Supervisor Cortese's report. You mentioned, coming back with certain information that could say during X number of days, these size boats. What is the term again where it goes into the water, that depth 1, 2, 3 shadow?
The draft.
The draft, thank you. The draft of the boat based on the depth. And I'm very interested in hearing what you come back with so that people trying to navigate those waterways don't run aground. On a regular basis, there's some consistency. I'm thinking of these waterways more as roads and minimum PCIs, pavement condition indexes, those kinds of things. So my staff and I have a great deal to learn about this. This is unique, I believe, to Supervisor Cortese's district. And so we've been coming up to speed very quickly, and today was very informative for me. And yes, I am fine with the direction that you gave as far as answering the questions and bringing this back.
Thank you. And Supervisor Wasserman already said it, and at least one of our speakers said it. This is, I think it's been a good investment for us to know what is and what isn't out there. As a Parks Department, as a county, and as a Board of Supervisors. So we're eager to get a little bit more information, but it's, again, as the speaker said, it's a very thorough report and very helpful, and I appreciate you putting up with our questions, especially mine. So we'll essentially, I think that motion is to receive the report, but with the notation that, with the request for information to come back. All right? Thank you. To give the clerk a little bit more clarity on that. You got it now, right? Okay. Thank you both. Thank you to the consultant. Appreciate it. I think this is 7. I think it's our last item. See Susan Gilbert Miller coming up.
Close to good afternoon, supervisors.
Right. After making you wait here all morning, I'm not sure we have a heck of a lot of questions for you, but we'll give you an opportunity to point out what you brought back to us and see if it prompts any questions.
Thank you very much. Well, we've submitted the semi-annual report that's dealing with the environmental stewardship goals, the county programs, and the sustainability master plan progress. And as you've seen, it's a consolidated report so that it's dealing with everything in a very holistic manner now, so that you can see the progress happening in terms of the goals and also the programs that are there to support and drive goal progress. We're happy to, and may I introduce, please, to my far left, which is your far right, Mr. Kevin Armstrong, who's with the Office of Sustainability. Right. He's been interim manager. He's been really wonderful in terms of holding that office. His last week is next week, and we're going to really miss him, and I want to make sure to thank him for all the work he's done.
Yes, thank you for all the work that you've done. You're not going to the same place as Mr. Courtney, right? Okay. Make sure somebody isn't pirating all our employees away here. Thank you, and you've been here before the committee before. Thank you for your work on behalf of the county.
And also to my left, your right, is Ms. Susanna Mercado, who's with Facilities and Fleet. And she's their Sustainability Program Manager, also who does a lot of work. And Facilities and Fleet generally does a lot of work to help move sustainability forward. We would be happy to answer any questions you have in the remaining time.
I mean, the only question I have is, we went over this, we kicked around what the schedule should be the last time, and has that presented any problems for you, just adjusting to what the committee's requested? That's the only, I just wanted to make sure that this is going smoothly for you. The report's great.
Thank you. The schedule, I'm still working to try to make sure the schedule's clear and that it's clear what we're reporting to FGOC and what's being reported to Hewlett. I'd like for them to be the same thing so that we're not writing different reports for the two different committees. So that's where this recommendation comes forward, where what's being recommended here is that the report you see before you would be the type of report you'd get semi-annually and annually, and then there would be quarterly reports that would, there'd be two other reports that would give you progress before the committee on what's happening with the Sustainability Master Plan development, and then anything that would be notable in terms of program progress or goal progress, we would also certainly include in that report. And then in addition to that, we've been requested to provide regular off-agenda reports on a monthly basis. So for any month that we're not reporting in front of a committee, we would continue to do the off-agenda reports.
Yeah, that sounds, and that would put us in alignment with FGOC from your perspective, what
Yes,
you just
sir.
described. Supervisor Wasserman, you have any problem with that?
I do not. I'm happy to make a motion to receive the semi-annual report. Excellent as always. Thank you, Susan.
Thank you.
And to your item B, recommend to revise the off-agenda reporting as specified, so that I certainly don't want you to have to be creating two different reportings for two different committees receiving the same information. And Kevin, best wishes to you. You betcha.
Okay, that motion is adopted unanimously by the committee, and so that wraps up item 8. Thank you again.
Thank you very much.
Okay. I think that brings us to adjournment, unless I missed something, Supervisor Wasserman. So we are hereby adjourned, and as Supervisor Wasserman pointed out earlier when I couldn't find it, we'll be back, at least as currently scheduled, on August 16th, 2018 at 10 a.m. If there's any revisions to that, the changes will be duly published for the public. Thank you.